The Big Beautiful Bill, How It Paves the Way for Lawsuits and What You Can Do About It. 1. The influence of the legal profession on legislation. Do you know how new laws are quietly making it easier to sue you? In today's video, we're breaking down how the Big Beautiful Bill changes everything for plaintiffs, and how it could cost you. In 2017, the U.S. saw the emergence of what some call the Big Beautiful Bill, a legislative piece that was introduced under the banner of the Consumer Legal Accountability and Fairness Act. However, beneath its appealing name lies a deeper agenda that benefits a specific group, trial lawyers. Many of the bill's proponents and architects are, in fact, trial lawyers themselves, with nearly half of Congress holding law degrees. This intersection of lawmaking and lawyering creates a feedback loop where laws are drafted to benefit those in the legal profession. These provisions not only lower the bar for filing lawsuits but also expand liability, making it easier for plaintiffs to bring cases. The game is rigged in favor of the legal community, as each new lawsuit translates to more billable hours and greater financial gain. The implications of this are clear: a system where the few benefit from the suffering of the many. Footnote: this section highlights how the legislative process has been influenced by trial lawyers, benefiting their interests at the expense of the public. 2. Expanded joint liability, paying for others' mistakes. One of the most alarming provisions of the Big Beautiful Bill is the reintroduction of expanded joint liability. This rule allows a minor player in a legal dispute, who may only bear a small fraction of the fault, to be held liable for the entire judgment if the primary defendant cannot pay. For example, a business owner who had little to do with the cause of a dispute could find themselves responsible for the entire sum if the primary defendant files for bankruptcy. This is an example of how the bill amplifies liability beyond what is reasonable, forcing businesses and individuals to take on excessive financial burdens for actions they were not directly responsible for. Footnote: this section explains the dangers of expanded joint liability, which forces individuals to take on greater financial responsibility than they deserve. 3. Lower filing standards, a gateway for frivolous lawsuits. Another major change introduced by the Big Beautiful Bill is the lowering of standards for filing lawsuits. This provision allows plaintiffs to file lawsuits with less concrete evidence, making it easier to initiate costly and prolonged legal battles. The result? More lawsuits, fewer defenses, and longer legal stress for defendants. This legal extortion tactic places a heavy burden on businesses and individuals, with costs adding up over time, regardless of the merit of the case. As lawsuits flood the courts, those without deep pockets are at risk of being financially drained by the process. Footnote: this section details how the lowering of filing standards enables frivolous lawsuits to thrive, placing financial strain on defendants. 4. Asset discovery, exposing your financial records. One of the most invasive aspects of the Big Beautiful Bill is its allowance for easier asset discovery. Under the bill, plaintiffs' attorneys are granted the ability to investigate a defendant's financial records before the court has even determined their liability. This preemptive invasion into one's private finances can expose sensitive information, such as bank accounts and property ownership, to potential misuse. The power to compel such disclosures can leave individuals vulnerable to further legal actions, even before any wrongdoing has been established in court. Footnote: this section explains how asset discovery provisions increase the risk of exposing personal financial information before a defendant has been found liable. 5. Public interest loopholes, a threat to professionals. The Big Beautiful Bill has provisions that reclassify certain private civil actions as public interest lawsuits. While this may sound like a positive step, the reality is that this change makes it more difficult for professionals, business owners, landlords, attorneys, and others, to recover their legal fees even if they win the case. This legal maneuver opens the door for aggressive lawsuits against professionals with deep pockets, leading to more cases being filed with less merit. In these situations, the threat of high legal fees forces many defendants to settle, even if they are in the right. Footnote: This section outlines the public interest loopholes that can force professionals to bear the cost of meritless lawsuits and potentially settle under duress. 6. Trusts and LLCs, increased scrutiny and piercing of legal structures. The final significant impact of the Big Beautiful Bill is the increased scrutiny on asset protection strategies, particularly trusts and LLCs. While offshore asset protection remains largely unaffected, domestic asset protection trusts and single-member LLCs are now more vulnerable to legal challenges. Courts are now more inclined to pierce these legal structures, disregarding their protective nature. This provision directly attacks traditional tools that individuals and businesses use to separate personal and business liability, making it easier for creditors to access protected assets. Footnote: this section discusses how the bill increases scrutiny on domestic asset protection structures, undermining their ability to shield assets from creditors. Now that you know the potential dangers of the Big Beautiful Bill, make sure you're prepared. Subscribe for more strategies on how to protect your assets and keep the lawyers at bay.